Well, welcome to you all for being here. Those of you who are familiar with the program will see that there's been a slight change in the batting order, to use a cricket expression. I am not Jennifer Davies, as some of you will be able to discern by my deep voice. She's unfortunately not able to attend, so I'm filling in as both the introducer of Marcello and also apparently to make some comments at the end of his session. Now, I'm sure most of you are here because you are intrigued by the first word appearing immediately after the full colon, which I am not able to say, let alone understand, but Marcello will no doubt explain it all to us all in a moment. My great pleasure to introduce Marcello Poggioli to you all. I have now known Marcello for a lot longer than he probably would like to remember. He's a professor at the University of Studies in Padua. And if you've not been to Padua, you should put that on your list. Not a bucket list, but a pre-bucket list. Get there as quickly as you can. It's a remarkable city, absolutely beautiful. It's where people like Galileo taught and is where Marcello now teaches, amongst other things, tax. He's a practicing tax professional with offices sprinkled in the north of Italy. I've certainly seen one in Modena and Padua, although I have not seen the one in Padua, but I have seen the door plate in the one in Modena. Modena is a nice place to visit as well. It's where they build Ferraris, and the people in Modena, like Marcello and those of Bologna, have been fighting each other for the last 600 or 700 years about who invented tortellini. And that's a good reason to go. Anyway, all jokes to one side. He's a leading practitioner and academic in Italy, and we're really delighted to have him here to talk about tax levies and legal certainty after the introduction of a general anti-avoidance rule. Marcello, over to you.
Well, thank you very much, Professor Poggioli. Thank you for your introduction, and thank you, Professor Miranda Stewart, for your invitation. It's a great pleasure for me being here, and thank you all for taking part of this seminar. Well, first things first, it is true, I do teach in Padua and do practice law in Padua and in Modena, which are two distant cities in Italy, 250 kilometers, and live in between. So I definitely do drive a lot during my week, but that's because of my personal history, how I began practicing, and because of the fact I moved to another place for teaching, then I have clients in a place, clients in another, and do teach in Padua. So I mainly spend my time in Padua because of the teaching activities there. But during the week, it might happen I go to Modena, and I do organize events from time to time with the local lawyers association or chartered accountants. I myself was born as a chartered accountant. My first degree was in business administration, and this is the main reason I do speak a little bit of English, while my colleagues in my University of Padua do not. It's not part of the studies normally done by law scholars that have been interested in foreign languages. But because I got my graduation in Milan at the University Bocconi in business administration, I had to learn a little bit of English, and that's the reason I got this competitive advantage over my colleagues that I tend to exploit whenever I can. So thank you again for inviting me. here. It's a truly great pleasure, and so the university my university, the University of Padova, is we say the second oldest university in Italy, and we say the second oldest law faculty in the world, being Bologna the oldest. At least this is what we pretend to affirm. The University of Bologna was founded in 1088. So is approaching the century, while Padova has just ended celebrating 800 years of life. So Padova was founded in 1222 and was founded by a group of students coming from Bologna that were unhappy about the situation in Bologna, that didn't feel free in learning what they wanted or teaching the way they wanted. So they founded a new studium, a new university of law, which was the University of Padova. Both universities grew a lot and nowadays have faculties in every topic, in every sector of studies. So they do have engineering, architecture, health, economics, etc., and medicine, obviously. And they're both famous for that. So both towns live a big part of their life around the university activities. Big part of the activities are based around the universities, and we do live with students all the time. And I'll say a couple of things about that. Again, this information will come useful in a second moment. And yes, because we're very old, we tend to use, as a university, we have this very bad habit of using old, ancient words, and it's a bad habit of scholars in Italy. They tend to believe that by providing easy things with a difficult name, they transform basic concepts into something that it's more sophisticated. And I did myself, I was guilty of this myself, and please, I owe you excuses for this. So sorry for using these words, which were out of place, but for some reason, because Italian scholars use this kind of how can I say, these words whenever willing to explain a possible contradiction or asking themselves if two things go well in harmony between them or are sharply incompatible. They use this terminology, which are two figures of speech taken from the art of rhetoric. Is that word correct? Rhetoric? Rhetoric, okay. And the first one, hendiadys, means when you express one concept by stating it with two words that are intertwined and in perfect harmony between them. So the concept here is harmony, a synonym, and on the other side, oxymoron means in sharp conflict or in sharp contrast. So is legal certainty and tax levies, do they are in harmony, or do they live in harmony, or is there a contrast? What is the consequence of the recent introduction, well, relatively recent introduction of the GAAR in Italy because as strange as it may result from the perspective of maybe scholars from other countries where the GAAR exists since 1930s. Was that the case of Australia? No, even before. Italy had not, from a legislative point of view, from a statutory point of view, we are a civil law country, had no GAAR until 2015. So the GAAR in Italy was introduced in 2015. And it was an inevitable introduction because of the situation we had, and became effective starting 1st of January 2016. And it is still in place, and it's the only GAAR that we have, because it's true from the European Union point of view. We had the anti-tax avoidance directive 1164 of 2016 that had to be enacted, and the directive provided another sort of general anti-tax avoidance rule under Article 6 of this directive. But it is a directive that is destined to operate only in the perspective of the application of income taxation, and only to corporate entities, which is the direct consequence of the European Union law being shaped around the concept of market and free competition in the market. So in order to affirm the existence of the market and to protect the market, there is the need of a European intervention in the field of income taxation as well, with the minimum standard of a general anti-tax avoidance rule. But this rule will operate only as far as corporate entities are concerned, so as far as enterprises are concerned, and as far as income taxes are concerned. So that will leave out all other entities, all other taxpayers, all other taxes. So no register tax, no local taxes, etc. And we did not enact specifically the directive because it was evaluated that the GAAR introduced in 2015 was already compliant to the text of the European GAAR. So it was kind of absorbed into the existing GAAR, and no enactment was done in that direction. Another possible general anti-abuse rule is the one stemming from the multilateral instrument that is the consequence of the OECD BEPS. I know Australia signed the multilateral and ratified it as well. Italy, for the time being, signed, but has not yet ratified the instrument, so it's not applicable to Italian tax treaties. So it's not going to be applicable to the Italian Australia double tax treaty, at least not until Italy has ratified it. So for the time being, we only have this GAAR. And
you accept questions again?
Sure. Questions are very welcome. So if you have questions.
So can you really
sure. Yes, please. Yes, please. Oh.
Gorgeous. Really?
Well, we're very famous in the world for our laziness. That would be a political answer. I'm not sure. I think despite the initial enthusiasm regarding the multilateral instrument, they need a lot of time to think about the consequences of that. So they're taking their time off for thinking about that. But I think it's definitely a matter of time, not a matter of if. So it will come. Maybe it's just around the corner. I mean, at least in my perspective, as far as I know. And in fact, we did sign the instrument in 2017. Don't know, Australia, maybe Australia in 2018 or something. But I saw it was already ratified. So only in 2015, we had this general anti-abuse rule, which is a true general rule, as we will say, despite the fact that we can say that tax avoidance is, well, probably, if not surely, as old as taxes. We do have, as scholars, we tend to remind ourselves that the first trace of tax avoidance we find in the Middle Age literature is from a famous jurisconsult from Bologna, where he was from the Marca region, to tell you the truth, but he studied for a long time in Bologna. His name was Bartolo from Saxoferrato. And in one of his consultations, he recalls the fact that in a given time, one municipality introduced a special tax for merchants entering the walls of the town for selling leathers and skins in the local market. And the municipality pretended to apply a levy, Gabella was the name at the time, a levy on all merchants taking part to the local market. And the amount of the tax levied had a parameter, and the parameter was the surface, the soil of the market that was occupied by the merchants and by the goods, by the skins and the leathers. And what they found, what the administration found immediately after was that there was a growing number of merchants that were not going to remain still in the market, but instead they were walking around offering their goods, their skins and leathers, keeping them on their shoulders and arms instead of, so they pretended they were not occupying any soil by doing that. And they pretended that in accordance with the strict interpretation of the new rules, they had no obligation to pay the tax because of that. And Bartolus, quite surprisingly, states that in his opinion, if the merchants enter the walls of the city for selling in the market, and they do sell in the market, they have to pay the tax anyway. And it's a kind of economic purpose, economic substance, or substance over form.
Form of theft, you mean?
Of Ramsay approach or something like that. Sometime before it ever was stated by the UK House of Lords. So the phenomenon is certainly very old, but we did decide to provide this kind of solution to the problem, to tackle this problem with the general anti-abuse rule only in 2015. So I'm trying to explain why that happened from my perspective, which is the perspective of an Italian point of view on this problem. and from the perspective of the Italian legal system, the Italian tax law system. The Italian tax law is considered to be an autonomous body of rules, is considered to be an autonomous science of law because of the presence of specific constitutional principles enveloping and embracing taxes specifically. What are these principles? Well, there's a number of principles. The main two principles that are relevant in defining the perimeter of tax law are the principle of, we call it principle of legal reserve, but we could say principle of legality as well. Yes, sorry, I don't use slides very often. No, it's fine. It's just for, I prepared slides, but just for the sake of, just because I wanted to demonstrate that I was willing to do that, but I do not.
Avoidance.
Yes, I didn't like, well, to tell you the truth, I didn't like very much slides when I was a student. So I'm keeping this idea as when I do teaching, and well, I like the fact that I leave the slides to my students and then I leave my ideas or something, but I don't like using them during the lesson because somehow when I was a student, that kind of turned my brain off. So just read the slides and not following what the person is saying. So I wouldn't want that to happen. And no, it's fine. No, absolutely. No, they're useful. They're useful. It's just my a trace of my personal tragic story as a student that still lives with me. I was saying there are two constitutional principles. One of them is the principle of legality, which has very well-known historical roots in the principle of taxation, no taxation without representation, basically. We'll come to that in a moment. And we have another principle, which is the principle of the ability to pay. And this principle defines, in a way, the genetic code of tax law in our perception. They are pervasive principles. And whenever dealing with tax problems, it's either a problem of Article 23, which is the legality principle, or a problem of ability to pay principle, which is in our Constitution, Article 53, sorry. What do these two principles say? These two cardinal principles shaping the substantive tax law. So the provisions determining if a certain situation is taxable and how much is the tax burden on that situation. The legality principle states that no personal economic obligation can be enforced nor levied on persons if not on the ground of a parliamentary law, a law of the parliament, a law. It says a law, and by law means a law approved by the two houses of the Italian parliament. That principle has two sides, or has two necessities behind it. The first necessity is the necessity of democracy in the approval of tax levies. So whenever dealing with tax obligations, consensus is needed by the same people who is going to be addressed by the levy. So it's the same people through its representative in the House of the Parliament that has to approve the new legislation regarding tax obligations. This is just half of the function of the legality principle. There's another one which is more relevant to our purposes today, which is a need for legal certainty. Why legal certainty? Because when we say the law of the Parliament, we mean a written law, a written text, statutory rules engraved in a text. And through the text, it is possible for the taxpayer, or should be possible for the taxpayer, to understand what is the tax treatment of any possible conduct. So the text becomes the mean through which legal certainty is assured to taxpayers. So it should be possible for any taxpayer, before determining himself, herself, itself, to committing to a certain conduct, what is the tax burden associated to that conduct. So if there were multiple conducts, multiple lines of action, multiple schemes of action available to the taxpayer, each of which bringing the taxpayer to a given endpoint defined economic-wise or juridic-wise, it should be possible for the taxpayer, because of the written text of the law, to determine ex ante, so in advance, which is the tax burden you need to pay in order to reach the final goal, the final result. So for that reason, we say the Article 23, the principle of legality, is as well the base, not just for the democracy choices, the democracy in tax choices, but also it's the legal base for what matters today, legal certainty. And on the other side, as if it was a second term of a balance, of a possible balance, we have the ability to pay principle, stating that all persons shall contribute to public expenses in proportion to their ability to pay. So everyone shall contribute in proportion to its ability to pay. This is a principle of tax fairness in the repetition of the tax levies. If you have more ability to pay, the more ability to pay, the more you have to pay. And the second paragraph of Article 53 pretends that the tax system as a whole follows a pattern of progressivity, meaning that the levy will increase as the ability to pay increases, but it will increase not just proportionally, but progressively, so that the incidence in percentage of the levy will increase as the income, capital, or abilities, other abilities to pay, other items displaying ability to pay will increase. And this is a principle of tax justice or tax fairness in the repartition of the levies. Do this principle work well together? Well, yes and no. They do work together because they both define the functions and the way of being of tax law. But it is where there is a point in which they do seem to collide. And this point is the problem of tax avoidance. Why that? Well, because the legal system is not, we say, it's not a Swiss watch. It's not as precise as a Swiss watch, and particularly in a case such as our system, which is a civil law system. So it's heavily relying on literal interpretation of statutory provisions. So it's the interpretation is very bound to the text, cannot go too much away from what is the meaning of the text, cannot get away from the meaning of the text, has to respect the boundaries of the possible meanings of the text. And for that reason, inevitably, the same essence, the same reason for which we do have legal certainty, the text, becomes the point of departure for another problem, for the problem of tax avoidance. Because inevitably, if we rely on words, we do leave room for conducts of the taxpayer that are faithful to, that are not in conflict, that are compliant with the text of the provisions, but may be contrary to, can I say, the spirit, the substance, the will of the legislator or of the legislation. So it could end up, the taxpayer could find in the text of the law situations that are compatible with the meaning of the text, but not compatible with the intention of the legislation. So this is where legal certainty and tax fairness collide. And we say that tax avoidance begins where interpretation ends. So where not situation that cannot be reached in through the interpretation. This is where tax avoidance begins. This is where the space for tax avoidance is created. And kind of curious that for tax avoidance, we use the term elusion. We elude, the taxpayer may elude tax provisions or taxation or tax obligations. And semantically, elusion comes from Latin, and it means making fun of. Now, ludus were the games. Eludere means making fun of something. And illusion, tax illusion, means making fun of taxes, of tax obligations. So the fight to tax avoidance began initially through what are generally known as targeted anti-abuse rules. So through a casuistic approach. As you see in the slide, there are two possible approaches to that. One is the closed list approach, which is a casuistic approach. You define the conduct that you assume it is elusive, that makes for avoidance, and you abstract that conduct into what you think is the correct tax treatment. So it's just kind of laser light intercepting a specific conduct and reconciling the tax treatment of that conduct to the ability to pay, so to the tax fairness principle. And so the two principles can be reconciled together. You have tax certainty again and tax fairness. Tax certainty because the text of the law will determine that situation to be taxable in a fair way. So tax avoidance has been was countered for long years only through that approach, that casuistic approach, or that closed list approach, very specific approach, very targeted approach. As this was thought to be the only way that was compliant with the legality principle. And there was a general fear. Yes, excuse me.
Is that successfully done?
Well, no, it was a continuous game of how can you say?
Cops and robbers.
Okay. Yes. It was difficult catching up because once the problem with this structure of casuistic approach is obviously that it's another text of substantive tax legislation that is rigidly written, and as any other tax provision, it's suitable, at least in the medium or long run, for another elusive conduct of the taxpayer. So it was a continuous maintenance of the tax system that may become excessively burdensome excessively expensive for the tax administration. But in the early 70s, when Italy enacted a very important tax reform, we had a group of 30 eminent scholars studying the legal system. That reform changed the face of the Italian tax system and brought it into what it is today, a mass tax system with an incredible number of taxpayers. But at the time, they had no idea of the consequence of this on the side of tax avoidance. And in the relation they made to the government before the enactment of the reform, they clearly stated that the problem of tax avoidance was so little, with so little numbers, that could be faced through the closed list approach. It should be approached with that type of solution only, and not by means of a GAAR, because managing the GAAR was too expensive. And they had the fear as well that the instrument of the GAAR was excessively powerful, and they feared to provide the tax administration with a too powerful instrument that they could not easily manage to operate with.
Courts support the administrator's view of what should be paid?
Excuse me?
The courts support what...
Oh, the court. No. The problem is exactly in the court, in the jurisprudence. But the court did support that view until a given moment. We did enact in 1997 a GAAR, a semi-GAAR, not a general clause, a semi-general clause, which was applicable only on income taxes. And it stayed and only to a given list of transactions. So in order to apply that clause, the administration had to scrutinize a situation or a scheme in which there was at least one of the listed one of the listed transactions. If none of the listed transactions were to be found in the scheme could not be denied, the tax advantage could not be denied. But if one of those not many transactions was to be found, then the administrative syndicate could go on and they could challenge the taxpayer of tax avoidance, where tax avoidance was defined as the gaining of a tax advantage that was not consistent with the system of tax law, was asystematic, that was the Italian word, was against the system. It was explained as something that was derived from the general principles underlying the statutes of taxation. So that was already a difficult operation to do, to derive what is coherent to the system of tax law and what is not. So that was a very difficult thing to do intellectually because of the nature of tax law, which is continuously modified. At least in Italy, we do have everyday modifications and new laws being enacted. So that makes it more and more difficult to derive in abstract these principles. So that was the situation after 1997, when we had this semi-general clause with a very short list of transactions, such as merger and acquisitions, the transfer of shares, these are just examples, the creation of a trust, and a few others. Mm-hmm. I'm sure. Trust came later.
We also have the GAAR.
So the trust came at a later date in the list, but there was a list of a maximum 10 transactions. And this provision was very scarcely applied by the tax administration. It did, however, have a very strictly defined procedure. So there was a procedure, and it was very strict, because the tax administration, in order to challenge the taxpayer, had to follow very strictly the procedure given under the penalty of nullity of all the procedure and of the deriving tax assessment. So they had the need to provide the taxpayer with enough time to defend himself, to explain, and it was a very articulated discipline from a procedural side. What happened is that at a given point, we had this so-called uncharted or not codified tax avoidance. This semi-general clause, what this semi-general clause provided was a general definition of tax avoidance. It said tax avoidance is whatever transaction, singular or a series of operations that are aimed at gaining a tax advantage that is against the system, against the will of the system, so against tax rules or tax principles. So given the picture of the general concept of tax avoidance, we had a huge amount of situations falling under the definition of tax, the general definition of tax avoidance, that the tax administration could not challenge. because there were no instruments. What did the jurisprudence do? Well, the jurisprudence seek to find alternative instruments to eliminate tax avoidance, to give the tax administration a possibility to neutralize such elusive tax advantages that were contrary to the spirit of the system. One of the first try was grounded on civil law. It was said that arrangements of the taxpayer that were aimed at tax avoidance were against principles, general principles of the law, and for that reason were to considered void. But the end solution was not satisfactory, in the sense that if all the construction is void, then you have nothing to tax. So that was rejected as a solution. Another possible solution envisaged by the jurisprudence was, again, taken from civil law. It was to consider the elusive scheme of action as a simulation. So we have a simulation whenever we declare we want to do something, but instead we internally want to reach another result. We provide externally the decision to reach a certain result, but internally between us, we have a different agreement. So what we declare is void. What is valid, what is applicable, is what we really wanted. But then again, this was unsatisfactory as an approach, because simulation is a type of tax evasion, not of tax avoidance. And tax avoidance exists for the fact that the parties really want to follow, under the light of the sun, that particular scheme of action, because they want to avoid because of that scheme of action. So the solution came in 2006 and came from the European Union Court of Justice case law, from a number of cases, one of which, the most important of which, was the Halifax case, which was a case on VAT. And the European Union Court of Justice at the time said that there is an underlying principle in European Union law, that is the principle of prohibition of abuse of law and of abuse of tax law as well. And they did apply the principle to a situation in VAT where there was no GAAR, no anti-tax avoidance provision. And they basically said, whenever such situation comes to existence where the taxpayer is abusing tax law, you have one avoided scheme, and you have the avoidance scheme that was followed by the taxpayer. You have to disregard the taxation of the avoidance scheme and apply instead the tax treatment of the avoided conduct. But it was the Court of Justice, and it was perhaps deciding surely in an harmonized sector such as the VAT, because VAT is a European Union harmonized tax. But it was decided with a scheme of interpretation that is perhaps closer to common law countries than civil law countries. But the Court of Cassation, the Italian Court of Cassation, the Supreme Court of Cassation, took that solution and transferred the same scheme of reasoning into its decisions. So it said there is an underlying principle stemming from the legal system as a whole, and we do apply the principle. The principle stemming from the European Union legal order. That was heavily criticized at the very beginning. Why criticized? Because it was said to be incompatible with the principle of legality. So if it's not written, it's not applicable. That's the idea. So after a year or two, after 2 years, in 2008, the Court of Cassation issued a number of decisions reverting its idea, modifying its line of reasoning. It rejected correctly the idea of transposing materially the same European Union principle to internal domestic tax law, at least for non-harmonized sectors such as the income tax. We do have a lot of tax avoidance in Italy, mainly in income tax matters, but said that notwithstanding the non-applicability, non-direct applicability of that principle stemming from the European Union law, it was still possible to apply directly to Italian taxpayers the Article 53 of the Constitution, so the ability to pay principle. And that principle could be applied to concrete situations directly, which was something completely new to our standards, because it was always understood that this article, the ability to pay principle, was, we say programmatic? No, programmatic?
There's such a word, but you didn't.
It's directed to the tax legislator. It's a program to be developed it's addressing the tax legislator, not the taxpayer, the principle of ability to pay. So it's something that is given as a program to the tax legislator, and it's not to be enacted directly, to be applied in concrete situations.
Directed to government.
Yes,
Directed to government.
to the government. Directed to the government and not taxpayer. But the Court of Cassation said, because we don't have other instruments available, we do apply the principle of the ability to pay to situation, and the prohibition of tax avoidance stems directly from that article. So we, as a judiciary, we are going to apply the principle to single situations whenever we do a judgment. We're going to fill the voids of the legislation with the case law, with the jurisprudence. So whenever we're facing a situation we believe it is contrary to tax fairness, to ability to pay, we intervene and we decide that it's tax avoidance, and we disregard the tax benefits deriving from the conduct, even if the semi-general clause is not applicable. So in that sense, the jurisprudence stepped in as a supplementary mean to combating tax avoidance. But that created a huge imbalance, a huge problem under legal certainty, in the perspective of legal certainty. As an example, it was said that even if the tax administration did not contest, did not challenge the taxpayer, did not contest anything as far as tax avoidance was concerned, the tax judges could, by themselves, autonomously state that there was a tax abuse or tax avoidance in the case, and decide the case for that reason, disregarding the tax benefits, the tax advantages of the taxpayer. So even if it was not in the Tax Assessment Act at the origin of the controversy, the tax judge could do that. Even the Court of Cassation could do that even if the lower judges had nothing to say about that. So it came out as something disruptive for the whole system, because there were no formal boundaries for that situation. So it came to a surprise to many of us as practitioners and as scholars as well. All of a sudden, everything became uncertain. When releasing legal opinion, everyone was saying, this is my legal opinion pro veritate, unless the judge has something to say under the abuse of Article 2053 scheme. So, and there was also a great misunderstanding in many decisions by the higher judges, even by the Court of Cassation, where they decided to disregard tax advantages simply. So they confused in many decisions tax savings with the concept of tax avoidance. So they simply compared the different schemes of action available to the taxpayer, and they pretended to apply the higher tax burden to situations in which there were no tax avoidance, because we were speaking of perfectly systematic conducts. So situations that were already, excuse me.
The fact that, you know, advisors would caveat their opinion to say that so-and-so position, provided the judge gives in the same manner. So I was wondering if there is no concept of an advanced ruling in your jurisdiction.
There is. The thing is, the tax administration is very likely to answer that there is a tax abuse or tax avoidance. So there is a trade-off when you do a tax ruling that is you voluntarily tell the tax administration you have a problem. And the tax administration, at least in Italy, the Italian tax administration, we do have a number of tax rulings released under the special scheme that is set for tax avoidance. So there's a possibility. But the number of rulings that do conclude in the sense that there's no tax avoidance are very limited in percentage. The vast majority of rulings end up with the statement that the situation is tax avoidance. So it really is the last resort. But at the time, there was really no possibility. It was a kind of the end. It looked like the end of tax planning schemes. Now we cannot do a safe tax planning because everything can be denied under that particular line of reasoning, and as well the line of distinction between tax avoidance and tax evasion became more and more confused under the name of tax abuse. We had situations such as the fictitious interposition of a third legal entity, for instance, which traditionally was understood as being tax evasion, but became a situation covered by the tax abuse under the most judicial decisions on the subject. So we had a very confused situation, a very unhappy situation. And the government felt the need to make an intervention, to step in and modify the situation in favor of more legal certainty. So they decided to introduce the GAAR. So the GAAR was introduced in 2015. And that certainly brought some more legal certainty to the table. and the GAAR is applicable starting from the 1st of January 2016. So we don't have a lot of experience on that. I'll tell you something about my personal experience in a moment. Still? Oh, that's too much. Okay. And that GAAR was introduced under Article 10. You see Article 10 bis. We do have this strange habit in Italy of releasing texts of law and in a later date make an intervention and inserting newer articles. So whenever we see Article 10 bis or 10 ter, 10 quater, it means that there was an intervention after the legal text was issued for the first time. And this is Article 10 bis of taxpayers' statute of rights or bill of rights. It's a parliamentary law that pretends to be a direct specification of constitutional principles, but it's a law. So another law could certainly modify it or derogate the statute of rights. Anyhow, in this article, we do have an Article 10 originally provided for by the statute of rights. And Article 10, it's about the relationship between tax administration and taxpayer. And it is was quite a good choice to use Article 10 as the platform for the insertion of the GAAR. So the Article 10 states clearly a number of things that are relevant for the functioning of the GAAR. First of all, it affirms the taxpayer right to tax planning. So the taxpayer can safely choose between different options provided for by the tax legislation without this being tax avoidance. The abuse of law or tax avoidance are considered as being the same concept. So there's no distinction between the two. They're treated as if they were the same thing or two sides of the same coin. And they can be challenged by the tax administration only residually, where residually means if there's no other instrument available to the tax administration. So if a breach of a tax provision can be invoked under the form of tax evasion, there's no possibility of activating the GAAR. It has to be contested a tax evasion, not an abuse of tax. There is a strict procedural path that has to be followed, again, the same way it used to be for the semi-general clause under the express penalty of nullity. So the taxpayer has to be given, for instance, 60 days in advance, an explanation of the reason for which the tax administration believes that there's a tax avoidance or tax abuse in this case, and the taxpayer has the right to present the defenses to that. And if the tax administration decides to issue a tax assessment, then the tax assessment has to be specifically motivated with regard to the defenses presented by the taxpayer. So if in the motivation of the tax assessment, the defenses are not taken care of and not considered, the tax assessment is void. it is stated expressly that the tax judge cannot autonomously decide a case on the ground of tax avoidance, tax abuse, if tax avoidance, tax abuse is not already part of the litigation. So it's not already in the tax assessment at the origin of the controversy. It is stated that in case of tax avoidance or tax abuse, there is no criminal penalty to the taxpayer. So the reason is the violation of the rules is not direct, it's an indirect violation. So it has to be not relevant for criminal purposes. Still, the taxpayer will get administrative penalties, the same as tax evasion. Not criminal, just administrative penalties. And there is another specific provision that we might recall. It refers to the tax collection. Typically, when there is a controversy beginning between the tax administration and the taxpayer, the tax administration has the right to proceed to collect taxes in the proportion of 1/3 of the taxes assessed, of the more taxes that were assessed. It cannot collect penalties, just 1/3 of the taxes assessed. And if the taxpayer is called provisional collection, so it's temporarily collected. If the taxpayer wins the litigation, the amount of money will be refunded. If the taxpayer loses and still go to appeal, then the tax administration can collect up to 2/3 of the tax and this time of the penalties as well. In the case of tax avoidance, there's no possibility of collection during in front of the first judge. So pending the controversy before, we do have tax judges organized as province tax judge, which is the lower tax judge. We have region tax judge, which is the third judge. And then we have the legitimacy judge, which is the Court of Cassation. Whenever the case is pending before the province judge, province tax judge, there's no collection if the matter involved by the controversy is tax avoidance. The reason for that, it is that the government believes that the tax avoidance is a very delicate matter, very complicated. And for that reason, no collection has to take place. So collection may begin only after at least one judge has confirmed that there is tax avoidance in the case of tax abuse in the case. How is this tax? Thank you.
Miranda, how we're going for time.
Do we have time?
Probably need to wrap up 25 so
almost done. Well, this is the structure of the GAAR. Abusive law is established when a certain operational sequence, that is one or more operations, so even one single transaction may fall within this definition, albeit formally complying with tax rules, is devoid of economic substance, and essentially achieves, there's an S missing, under undue tax advantages. Undue refers to benefits achieved in contrast with the purposes of tax rules or the principles of the tax system. Everything looks relatively understandable, at least on the first two tiers. Operational sequence is reasonably understandable. Formally complying with tax rules, it is understandable as well. Still devoid of economic substance, it's becoming a bit unclear. And another part where the clause is not so easy is where it states that it's due to recover undue tax advantages. But the problem of undue tax advantages is the same problem we had with the semi-general clause. So it's determining what is the standard of the system provided by the system, what are the principles, or what are the single relevant rules that are circumvented, that are avoided, which is difficult to do, or at least not always an easy task to be accomplished. And from time to time, it involves some subjective skills or some subjective sensibility. To me, there is a given principle. To you, it might be you think differently. Yes. Yes, it's defined in the legislation expressly. Yes, this is the GAAR. This is the GAAR. This is the first two paragraphs of the GAAR. And it's all, this is all on the burden of proof is on the tax administration. It's the tax administration in charge of providing evidence that these requirements are met. There is only one possible escape for the taxpayer once these elements are given evidence of by the tax administration, is that the taxpayer may provide evidence that the scheme of action was inevitable in his situation. That excludes the tax avoidance, but that's the only possibility, the only thing that lies in the hands of the taxpayer as a burden of proof. Obviously, the taxpayer may provide evidence that one or more of these four requirements are not met. What is difficult is that all four requirements, all 4 points must be met. So in literature, it is said that the GAAR is like a cylinder that is very wide at the top and at the bottom because it encompasses all the taxes, all possible taxes, and it regards all possible transactions and operations. But it becomes thinner in between because of the need of the lack of economic substance, which is something that is very difficult to understand in the meaning. And it is as well difficult to define, or at least it is subjective in a way, in a certain way, to establish what is in accordance with the principles of the tax system and not in accordance or against the principles of the system, which involves the knowledge, the understanding of the system as a whole, which is something that, according to some, is an impossible task. How often? Not very often, but what happens, at least in my perception, is that from time to time, the Central Tax Administration issues directions to its local offices to put attention to given situations and to verify those situations under the GAAR. What I was willing to say about my personal experience in my very limited practice as a lawyer. I have now 5 cases on my table regarding the GAAR, the application of the GAAR, 2 of them in the same period where the GAAR applied to domestic transfer pricing. So transfer pricing between companies resident within the boundary of the state. So 2 Italian companies and transfer pricing between them. We do have transfer pricing discipline, but it's applicable only to cross-border situations. And I have 3 other cases which refer to, we call that leveraged cash out. No cash out, income tax, if I may, spend another minute. No, cash out. It's when we do, well, income tax is on individuals initially is progressive as a tax, progressive by brackets. The higher tax rate is 46%, so it's quite high. But very often now, the tax legislation offers to taxpayers the opportunity to apply instead for given items of income a fixed tax rate in order to anticipate the cash flow, the tax flow, the cashing in of the taxes. And one of these provision states that if you own shares and you bought these shares at a given cost, you can rectify that cost to the actual current value of the shares. Exactly, push up the cost. We call it actualize the tax cost. And you pay a very low fixed tax rate on the difference. So the big advantage of that is that should you sell the shares tomorrow, you could rectify the value and a minute afterwards sell the shares, and you will not pay the capital gain with the brackets in the progressive, because you already renewed the cost, paying, it used to be 4% for a given time, now it's 8%. Now, big entrepreneurs having the shares of big companies, in order to cash in money, leveraged cash out, yes, in order to cash in dividends, maybe, they had their shares rectify, actualize in value, so they pay 8%, and then they sell the shares to one of the companies of their group. So they are the owners of company A and company B, starting position. Then they actualize the shares of company B and they sell the shares of company B to company A. And maybe that's leveraged because they lend the money to company A to buy the shares. So by doing so, yes, they monetize, they receive cash, and they pay 8%. While if they receive dividends or if they sold the shares, they had to pay on a much higher amount. So for that reason, that is being challenged now under the GAAR. And we're starting to have jurisprudence stating that this is tax abuse, tax avoidance. Yes, you transform a dividend into a capital gain that is not taxable because you actualized. So yes, it's being used. It's not the black dog.
No, not a black dog.
But
sorry,
it's,
I'm conscious that we need to let say fine.
oh no, it's a bit silly. No, well, I had to say something really, but it's a very light note, so sorry for that. I hope you'll forgive me for this. Seriously speaking, yes, the GAAR brought in more tax fairness and more legal certainty. So it was welcomed as a very good addition to the tax legislation. It was necessary, absolutely. We couldn't do without. For sure, there are difficulties, and there will be difficulties in applying this GAAR, which was made as an hybrid, combining the national jurisprudence and what comes from the European Union, the recommendation against aggressive tax planning. So the economic substance is taken from there, and it's something we're not very familiar with. So this will lead in time with some price to pay in terms of legal certainty, for sure. So, and the fact that we have a lot of jurisprudence saying that the judge can apply directly Article 53 of the Constitution is certainly still there, and it's ready to be reopened, to be in a given moment, we don't know when, by the judiciary. Because if they have the power to apply a constitutional principle, which is of a higher standard than the legal provisions enshrined by the law, then at any moment, the judge can say, I will disregard Article 10 bis, the GAAR, and it will apply the Constitution instead, which is of a higher hierarchy level. So there's still a lot to understand about the new equilibrium the new setting we'll be reaching. So, but if I had to provide my final diagnosis, this is the joke I wanted to tell you about, is it's taken from the novel of Pinocchio, which I'm familiar with for family reasons. I have 3 kids, but it's very up to date. I saw there are films on Pinocchio from Disney, from Netflix as well. It's a wonderful film. At a given point, the puppet Pinocchio is hung at a big oak by the fox and by the cat, the 2 infamous dog, fox and cat, and the fairy with turquoise hair decides to rescue Pinocchio. And once she has rescued Pinocchio, she puts Pinocchio in bed and calls 3 famous magicians in order to verify if Pinocchio is still alive or if he is dead. And they soon arrived, one after the other. They were a crow, a owl, and a talking cricket. There's even, yes, there they are. I should like to know from you, gentlemen, said the fairy, turning to the 3 doctors who surrounded the bed of Pinocchio, I should like to know if this unhappy marionette is dead or alive. At this invitation, the crow stepped forward first, tested the pulse of Pinocchio, tested his nose, and then his little toe. When he had examined him, he pronounced these words, "It is my belief that the marionette is quite dead. But if, unfortunately, he was not dead, then this would be a sure sign that he is alive." I am sorry, said the owl, to have to contradict the crow, my illustrious friend and colleague, but I believe that the puppet is still alive. But if, for some reason, he was not alive, then it would be a clear sign that he's really dead. And you, don't you hold an opinion? The fairy asked the talking cricket. I say that a wise doctor, when he does not know what he's talking about, should know enough to keep his mouth shut. Okay.
Well, Miranda, I think my task had been to comment on the paper, but I suspect we've run out of time. And it's, I must say, it's a riveting place to end by talking about these films, because I've certainly found this more riveting than the most recent Indiana Jones movie. But just to say nothing of the latest Barbie movie, which I saw the other day. So it's very good, but we have run out of time, I think, have we not? Yeah, we have. So I've got all these points that I was going to raise with you, but I'll have to do that privately.
I'm very sorry.
No, well, it's a great pity. And I'm sure there are lots of questions that people want to ask, but thank you very, very, very much.
There's another slide at the end with my email address. Should anyone be interested in asking questions, I'd be very happy to reply.
Good. Thank you very, very much. It's lovely to see that Italy has such a civilized system. And frankly, Kevin, I can't see the mischief in the example that was used, but that's another story.